which are reversible error. The first was that the trial court denied the defendant's motion to suppress his statement to law enforcement. That was a custodial statement. It was not made with the requisite knowing and intelligent waiver. When Mr. Labor was arrested, he was arrested early in the morning at his residence. When he was arrested, he was immediately placed in a law enforcement vehicle. The officer.
When was he read Miranda? At the same time he's put in the vehicle?
Yes, Your Honor.
And is there any doubt the entire Miranda warnings were read properly?
Your Honor, Miranda was properly read.
It's
That's
the
not
intent
the-
of the recipient. Mr. Labor claims he didn't give a free and voluntary confession because they didn't tell him why they were there. It took him a while to find things out, but he agreed to speak. Is that true or false?
That is true, Your Honor. The problem is, as the court just articulated, he did not know why he was there. He asked repeatedly what was going on, why he was being arrested, and the officer didn't tell him. Now, that's not the only part of the problem. The officer also did not do what the statute requires and provide to him a copy of the search warrant that the officer was then executing.
Well, counsel, isn't that statutory requirement a post-seizure requirement, meaning that that's something that's done after the seizure? And don't the cases say that in those cases there's really no constitutional imperative there?
The constitutional error here, Your Honor, is not only the failure to deliver the warrant. The constitutional error is the lack of a knowing and intelligent waiver. Now, if the defendant had been told why he was being arrested, that would certainly be a first step towards a knowing and intelligent waiver. In addition, the warrant sets out why he was being arrested. It's page 80 of the record. If we look at page 80, we see that the defendant was accused of distributing images, movies, or visual depictions of sexual conduct or sexual performance by a child or children. Now, had the defendant been provided a copy of the warrant as the statute requires, he would have seen that in the warrant. That would have answered his question. But the officer was required to comply with the provision of 933.11, quoting from the statute. When the officer serves the warrant, he or she shall deliver a copy to the person named in the warrant. Well, defendant was present.
Let me just interrupt you because I understand the argument. I understand the best law enforcement practice would be to give them a warrant to say all these things, but that wasn't done. So the question is, let's just take it down to the failure to provide a copy of the warrant immediately. They eventually did, correct? So they left it somewhere at the house. Is the remedy spelled out in the statute? Oh, and by the way, if you don't provide the warrant, you're going to get your confession suppressed. That's not in the statute. So the remedy is maybe the cop has to go get a little more training or something. It's not a suppression automatically. You're asking for us to expand Miranda, automatically suppress the statements for the arguments you just made.
No, Your Honor, it is not automatic. In fact, there are courts, Florida courts, that have held that failure to provide the warrant is simply failure to comply with a ministerial act. The problem in this case is not only the failure to provide the warrant. The problem in this case is that the defendant's waiver was not knowing and intelligent because he had no idea what he was facing.
But didn't Labor make some unsolicited comments that weren't even questions when he said, I've been hacked, child pornography images are hacking up, popping up. I don't know what's going on here. It's not me. Then the officer started to explain, we have an IP address someone would have to be here, they have to download it, it's almost impossible for this to have happen through hacking. Then there's a big debate, and they kept saying, I've been hacked, I've been hacked. I didn't do anything wrong. And it's almost like he knew why they were there. There's an implication of what reading this. They didn't necessarily have to tell him because he really knew. He was either playing coy or, curious or whatever, because maybe you want to make sure it was this and not something else that he might have done. That's the way I read that.
Well, perhaps later on in the events that the court mentions were later in the interrogation after he had already made incriminating statements. Perhaps as the discussion with this law enforcement officer went on, he came to understand what this was about. But the difficulty here, again, is that the initial waiver was not knowing and intelligent because he did not, at the beginning, apparently understand. I mean, the court commented that perhaps he came to understand and later on said he had been hacked, but certainly the waiver is required at the beginning of the statement, not at the end. In fact, there's some decisional law addressing
So
specifically
why did the
that.
judge rule against you? But did the judge articulate why he denied him? I mean, you have a 200-page transcript of the hearing. Howell testified and your client testified. That's unusual. And the judge didn't buy some of what your client said, or he would have ruled in his favor. If he really thought it was an involuntary confession, you win. So that there's a little bit of credibility involved. The judge gets to make that call, the trial judge.
Your Honor, I think that's a pure question of law for this court that needs to be decided de novo. The trial court judge clearly erred. Now, that gets to the second part of the issue before the court today, which is the trial court judge decided the motion to suppress. The same judge had issued the warrant.
Right.
Now, that is a de novo question. We unfortunately
You're
have
switching
no
arguments
authority.
now. You go into a different argument.
Yes, Your Honor.
Okay,
Second part of the argument.
gotcha.
The trial court judge should not have been the person to decide whether or not he, the same judge, had properly issued the warrant. Now, we do not have a Florida case directly on point. We do have some federal case law.
Well, counsel, is that issue even preserved? I mean, did you, if you didn't file a motion to accuse the judge at that point of getting off the case, I mean, how was that argument even preserved?
Trial counsel brought that up in the trial court at least twice, Your Honor, record page 166 and record page 345. Even if the trial counsel had not brought it up, it still amounts to fundamental error. I think that question, which has never really been decided by a Florida court, is fundamental to the
How do we
case.
know it's fundamental error? How does that reach down into the validity of the conviction that we can see on the face of the record? Oh, it's the same judge. Suppose that was an idealistic judge who separates themselves and be perfectly fair the first and the second time around.
Judge, we know from canon
You're asking
3.
us to find bias per se, essentially.
Sir?
You want us to find bias per se
Yes,
of the judge who read the warrant and the judge who heard the motion.
yes.
Okay.
This judge was reviewing his own work. There is no question that an appellate judge cannot review his own decisions as a trial judge. If a person is elevated from the circuit court to the district court, that person cannot sit on a case that he heard in the circuit court. No question at all about that. Canon 3E1 provides that a judge must disqualify himself when he served as a lawyer or was the lower court judge in the matter in controversy. That is exactly what we have here. We have a judge who was reviewing his own work. Now, we all know,
Well, you cited a death penalty case out of Pennsylvania, right?
yes, I did.
And we all
Williams.
know death is different, so that's gonna separate, and there's no appellate court before. I think the closest thing you got is Jones v. State, and I was on the panel. And I just made a passing comment in dicta that this case was unusual because the same judge who did the warrant, he did the motion. That is unusual.
It is unusual,
But
and,
there's no-
and it should be completely unusual. That should never happen.
But you make the argument for the first time on appeal. Saying it in passing in the trial court doesn't preserve an issue for review. This is the first time that it's made on appeal, is today, in the briefs.
This is an issue that is sufficiently important that this court should treat it as fundamental error.
Okay, well, you
Even
said
if this
that.
court,
We'll
even
have
if
to
the
figure
court,
that out. Oh, I understand the argument.
I can't go back and correct the record. I wish I could.
Well, fundamental error is it's the highest bar you can have. Very few cases have fundamental error. I mean, from my perspective, and you probably know this because I've seen you for 25 years now, the appellate court gets a judgment from the trial court, it's presumed to be correct. We have a duty to presume it correct. You have the burden to show reversible error. Not just error, not just that it wasn't a perfect case, but reversible error. It's a high burden that you carry. And so far, you know, you're doing a great job. You have unique arguments, and you always do a great job, but I don't see the reversible error. I'll have to convince you on that one.
Your Honor, one of the things that is most important to due process of law is the appearance of due process of law. Our courts have great authority because people do what the courts tell them they should do. They do that because they think that they have been properly heard, and even if they don't agree with the decision of the court, they will abide by it. Now, there are a few people who don't. They often get held in contempt, but that's an unusual situation.
So basically, you're looking for us to accept your argument as the best argument, and we should go with it. And looking for us to undo the conviction, send it back to quote a new trial that has no evidence, because the motion to suppress is found, all that flows from that is through Poison Street. He has no evidence against him to be convicted. Is that where we're headed with this?
Well, that's where we're headed. I'm not sure that there was no evidence. There was certainly other testimony unrelated to the,
From the
unrelated to the warrant.
Well, the guy got 2 consecutive life sentences followed by 49 counts concurrent 30 years. He'd never get out of jail if his conviction stands.
That's
I mean,
correct.
it's a heavy burden that you
That's
carry
correct.
today. I understand, all right.
So it would be not correct to conclude that there was no evidence against him. There was
Well, that's a
evidence
question.
against him.
Maybe there's some, but certainly not enough to give him 2 lives followed by 30. Like
Well,
the trial judge was that enamored with his argument that he's looking at something similar, and then you would probably make the argument, I need a different judge. He needs to be recused for the reasons you mentioned in the past.
well,
That's a separate issue.
that may be, but that's another question for another court on another day. The unfortunate issue here is that this simply does not look like due process, where we have the same judge reviewing that judge's earlier decision. We all, none of us, likes to admit we made a mistake.
Well, do you claim there's any defects in the warrant?
No, Your Honor, we didn't raise
So
defects in
it's
the
kind of like, if that's accurate, and I'm sure it is, it's kind of harmless when you don't have any defects that he reviewed improperly. He didn't rubber stamp a glaring defect saying, oh, it's a fine warrant to me.
Well, the problem is not, we didn't argue defect in the warrant.
You're,
problem-
what, as I understand you, I'm sorry to interrupt, but you're just arguing the appearance of it.
I'm not arguing just appearance, there is certainly a substantive issue here. If, for example, this trial court judge had been selected to sit on this court, that judge, that same human being, could not sit on a panel reviewing his own case. Unfortunately, that's exactly what happened here. The trial court judge reviewed his own earlier decision. Well, we can understand, I don't think I need to explain why that's a problem. If nothing else, it is a problem of appearance as well as a problem of substance.
Mr. Costin, you're at your 15-minute mark.
Right, well, if there are no other questions, then I would ask to reserve the remainder of my time for rebuttal, please. Thank you.
Good morning. May it please the court. My name is Alicia Winterkorn, and I represent the state of Florida, the appellee in this case. Appellant's first issue can be
Well, can I interrupt you because he left with the second issue? Could you tell us, A, do you agree it's preserved or not preserved? And B, how does it make a difference in his case?
Yes, Your Honor.
The warrant being the same judge as the motion judge.
Yes, Your Honor. So appellant's second issue is not preserved for appellate review. At the outset, there were two instances in the motions that were filed at the trial court where, and I believe the exact quotation was, notably, this is the same trial court judge that is now assigned to preside over these proceedings.
So that was happenstance. He didn't pick the case because he thought the motion might come up and he had to affirm his own warrant. That was happenstance by a random assignment.
That would be to my knowledge, Your Honor, yes.
It's not such a small county that they could not have found a different judge to sit in for the motion.
Your Honor, I'm not sure about that. I
Okay,
do.
that's fine. You don't have to answer.
So in the motions at the trial court level, it was in the facts section.
I think it's Hillsborough County. I think we can take additional notice. That's a pretty large county. We might be in Hillsborough right now.
Yes, Your Honor.
Anyway, your turn.
Yes, Your Honor. So it's not preserved. There was no motion asking the trial court to review, to disqualify itself or to recuse itself. Therefore, it's not properly reserved for
But it
appellate
looks
review.
bad, right?
I'm sorry.
It looks bad. It looks bad. Same judge who did the warrant is ruling on whether it's a good warrant or not.
Your Honor, and that is appellate's argument that it appears to be improper. However, there's nothing in the record that shows that the trial court based its ruling on the validity of the search warrant or any of the pretrial
Well, the other question
motions.
is the motion expressed speaks for itself. It doesn't talk about defects in the warrant, does it?
There were motions at the trial court level that talked about
Separate motion.
separate motions that are not raised on appeal,
They're not.
that talked about the validity of the warrant, that were not brought to this court's attention and were not briefed before this court. But there's nothing in the trial court's ruling that even gives an inference that the reason why the trial court denied the motions at the trial court level was because he was the same judge that signed and executed the search warrant.
Okay, right. I threw you up to your game. Go back to the first issue. I didn't mean to interrupt you.
No, Your Honor. And just to clarify, appellant cannot show that an issue to the judge recusal is any error. He cites to absolutely no authority that requires a trial court judge to recuse himself or to disqualify himself. Therefore, it cannot be said that this is fundamental.
I mean, your argument is basically, hey, It's 2 + 2 is 4, whether I say it once or twice, it's still 2 + 2 is 4. It doesn't have to be a different judge to say the second time my math is right, if it's right.
Correct, Your
I mean,
Honor.
that's essentially what you're telling us.
Yes, Your Honor, there's nothing to say that the trial court erred in either signing the search warrant or in his rulings based on the state's opinion on the various pretrial motions that were filed. Moving to appellant's first issue, it can be broken up into 3 sub-issues, 2 of which were argued today by appellant. The first, appellant argues that he cannot knowingly and intelligently waive Miranda rights because he was not informed of the allegations against him at the time that he was given Miranda. However, there's no case law that requires this. At the beginning of the recorded interview, appellant was given Miranda rights. Appellant then repeats back that he understood that he has a right to an attorney, and then questions followed. Shortly into the interview, when background information was being asked of appellant, for instance, who are the people that live in your home? What about the
Mental illness.
internet, etc. Once the child pornography allegations were raised, it was appellant, as Judge had pointed out, that first initiated the conversation around child pornography on various devices.
But counsel, didn't the defendant ask the question as to what he was being charged with at the time that the detective was actually asking him things such as your name, what school did you go to, et cetera, et cetera. The first time he asked what he was charged with, it was not involving testimony concerning the child pornography or the telephone or anything else.
That's correct, Your Honor. The first time that appellant asks, it's just when Agent Powell is receiving background information. The second time that appellant asks, it's when they're starting to get into child pornography. And that's when Special Agent Powell says, well, this is what it's all about. And then it appears on the transcript that Special Agent Powell and appellant appear to talk simultaneously based on the notes of the transcriber. And then Special Agent Powell goes in saying, it's because of what you just said about your accounts and about the child pornography. And then the discussions are largely focused on child pornography and the way that the email accounts and everything unfold.
Well, counsel, let me ask you this. The cases you cite, primarily State versus Jones and even the Supreme Court case of Colorado versus Spring, in those cases, the defendant read his Miranda rights on and advised of one crime, and then the detectives asked about another crime without informing him that they were moving into a different area. Aren't those cases a little bit distinguishable from this case, where initially the detective tells the defendant nothing about the offense in which he's been arrested? In those other cases, the detective told the defendant at least about one of the offenses that he was being arrested for.
Your Honor, in State versus Jones, they found that appellant was given Miranda warnings and informed of one allegation. And like you're saying, later on, the investigation turned to a second allegation. But the 4th DCA found that they did not need to give a second set of Miranda for that additional set of allegations. And the Miranda warnings go to the appellant's ability to know his rights, not necessarily know of the charges. Miranda goes to, do I have a knowing and intelligent waiver of my constitutional rights? Not necessarily, do I have a knowing and intelligent waiver to my constitutional rights for charge A or for charge B. And in Colorado versus Spring, they did hold that when the police did not inform him of the charges, it was not error. And it didn't relate to, and they focused a lot on coercion in that case as well. And in that case, they said that the Miranda warnings ensure that a waiver of their rights is knowing and intelligent. Again, reiterating the state's position that the Miranda is for the rights and not necessarily for the charges.
Well, the other thing is, in your typical investigation setting, the officer interrogating has a game plan. He or she is gonna ask the questions in the order they want to. They control the questioning. They don't direct the questions and answer to another question. I've never seen that happen. I mean, it's a nice try, but the cop is in charge of the investigations from what I have seen. That's more of a, less question, more of a comment.
Yes, Your Honor. In moving to appellant's second sub-issue, appellant alleges that it was error for law enforcement not to either read him a copy of the search warrant or to hand him a copy of the search warrant at the time that it was executed or shortly thereafter. However, Florida statute 933.11 and Florida case law provide that copies of the search warrant and subsequent inventory sheets, if applicable, can be left in the home for a cohabitant. And here in Hardin, the court in Hardin required that even if it was error for law enforcement not to give appellant a copy or to leave, or the failure to leave a copy inside the home, the appellant has to show prejudice, and that prejudice has to go to solely the failure of the delivery of the warrant. Appellant has not shown any prejudice here as to the failure of the delivery of the warrant. And in this
Well,
case,
counsel, doesn't the appellant merge his last argument with this argument by saying that had he seen the warrant, he would have known what the charges were?
yes, Your Honor, that is my understanding of appellant's argument, is essentially conflating the two together, saying that I could have either been told or I could have seen a copy of the warrant. Regardless of how appellant could have been told about his charges, whether that be written, oral, him reading it himself, etc., the argument in our last issue is still the same. Regardless of how he could have been told, it was still not error. Case law and Florida statutes don't require appellant to be aware of the charges to knowingly and intelligently waive Miranda. So subsection 2, the separate issue of just the failure to hand him a piece of paper, read him the charges, is not error in this case. Appellant here is asking this court to make numerous per se rules, which this court has declined to do in the past. And if this court has no further questions, the state will rely on the arguments in its brief, and we ask that this court affirm appellant's judgment and sentence. Thank you.
I will limit myself to the arguments by counsel. First off, counsel argued that there is no authority for a trial court judge to not review his own decision on a warrant. That is simply not correct. The authority is Canon 3E 1B. Counsel represented to the court that there's no requirement for an officer interrogating a suspect to give the subject to tell the suspect what charge may be preferred. Well, that's not the problem here. The problem here is that the defendant's waiver was not knowing and intelligent because he did not know what charge might be preferred. Counsel also represented to the court that it is proper for a warrant to simply be left in the house as opposed to delivered to the subject, to the individual. That's not what the statute provides. The statute, I will quote from the statute, provides, quote, when the officer serves the warrant, he or she shall deliver a copy to the person named in the warrant, or in his or her absence to some person in charge of or living on the premises. Well, here the defendant was not absent. The defendant was right there with the officer And the officer could have handed him a copy of the warrant. In fact, the officer was required by statute to hand the defendant a copy of the warrant. He simply did not do what the statute required. Now, the result of that is the failure of a knowing and intelligent waiver. And as a result, the defendant was prejudiced because he gave a waiver that was not knowing and intelligent. The officer could easily have corrected that. The same officer who had the warrant issued was the officer doing the interrogation. This was not a situation where some third party was doing the interrogation. The officer knew what this case was about. He knew what he was looking for. And he, by his failure to comply with the statute, prejudiced the defendant. Therefore, if there are no other questions, I would ask that this court reverse the conviction and remand the case for a new trial. Thank you very much.
Right, next we have Gillis versus Jackson